Continue case. Serial number 10, Criminal Division 1227 of 2016 along with item 11.
There is only one single ground in both the trial court and appellant court that the legal enforceable debt was not proved because the agreement which with the complaint alleged that the agreement was executed for transfer of the land and the said agreement was not executed and not brought on because neither in the complaint nor during the deposition of the complainant.
Read the judgment ऐसे एक सेंटेंस बोल के चुप होने से तो नहीं होगा ना। आपका तो डिफेंस ही था द कंप्लेनेंट शुड हैव फाइल्ड अ केस फॉर स्पेसिफिक परफॉर्मेंस ऑफ कॉन्ट्रैक्ट दैट वाज योर डिफेंस complainant should have filed a case for specific performance of contract.
If there is agreement among the parties.
That's right. Issuance of check is not in dispute.
If the admitted
Check is admitted.
Exhibit 1 is the signature of the petitioner.
Sorry?
Exhibit 1, that is the petitioner of the complainant.
That's right. The check is not in dispute. What have you done to discharge your discharge the presumption?
Several judgment of the tax court also to bring the case into 158 and I Act also the presumption of legal debts that need to be established by the complainant. Here there is no any legal debt.
Presumption of legal debt has to be established by the complainant. So presumption का क्या मतलब?
The legal debt.
No. There is a presumption, and then you have to lead some evidence to dispel that presumption. Where is that evidence? It's not there. You have not led any evidence, did you?
Mediation के लिए we are not appearing in the case despite of several.
So क्या मतलब है? Not appearing in the case. एक पहला वाला केस का Complete case 1981 of 2007. TR number 956 of 2012. TR number 813 लिखा है सर मैंने। Complainant was examined as PWC.
One. CW Procedural.
नहीं आते हैं। आपको क्या बोले? ये बोल रहे हैं कि agreement was not executed and therefore the debt was not proved.
Well, there is all the verbatim are there, my lord, that a sum of rupees 1,41,000 was paid by the petitioner before lordship to the complainant in respect of the same amount. And for that he has ultimately and then 24,700 for construction of boundary wall. And thereafter complainant approached the person several times. Then he refused. सारा विटनेस सपोर्ट किया है, हम चेक को प्रोड्यूस किए हैं, चेक डेटेड 10/8/2007, 80,000 का चेक है।
That's criminal revision number
The
1.
second case, not the accused is same.
Sorry. Actually, accused is same in item 10 also valid and item 11. So that goes to say that he is a habitual.
Complainant same है.
Say complainant are different. Complainant are different.
Different है, accused से.
Accused है. My lord, could you?
Criminal revision number 1227 में आते हैं. Yes, 1227 में आते हैं. For the learned counsel for the parties, this revision is directed against the judgment dated 21/9/2015, passed by learned Additional Judicial Commissioner, Roman 7 Ranchi, in criminal appeal number 156 of 2012, whereby the appeal filed by the petitioner has been dismissed. The petitioner has been convicted for offence under section 138 of Negotiable Instruments Act. White judgment dated 2/6/2012, passed by learned Judicial Magistrate First Class Ranchi in complaint case number 1981 of 2007, TR number 956 of 2012. The petitioner has been sentenced to undergo simple imprisonment for 1 year and has been directed to pay a compensation amount of rupees 1 lakh to the complainant under section 357 with the bracket 3 of CRPC. The learned counsel for the petitioner submits that though both the courts have given concurrent findings with regard to concurrent findings while convicting the petitioner, but the legally payable debt was not proved by the complainant, inasmuch as the agreement of sale with regard to the property was not produced and exhibited by the complainant. He submits that on this count, the impugned judgments call for interference. It was for the complainant to prove that there was a legally payable debt. The learned counsel appearing on behalf of the opposite party number 2 has submitted that both the courts have given concurrent findings after appreciating the materials in the court. He has further submitted that once the check is issued, there is a presumption in favor of the complainant, and the said presumption was not dispelled by the accused even on the touchstone of preponderance of probability. He submits that mere non-filing of the agreement of sale is not sufficient. The entire transaction was duly mentioned and narrated by the complainant in his evidence. That's it.
But
After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that it was a specific case of the complainant that an agreement of sale of land was entered into with the accused and the complainant paid an advance amount of rupees 1,41,000 and a further amount of rupees 24,700 was paid to the accused for the purposes of construction of the boundary wall on the land. But in spite of repeated request, the accused did not register the land in favor of the complainant, and upon request of the complainant, he returned the money by issuing check on 10/8/2007 for a sum of rupees 80,000 drawn on Bank of India, which upon presentation was dishonored on account of insufficient fund by check return memo dated 10/10/2007. The matter was informed to the complainant, to the accused, who asked the complainant to wait for some time, and ultimately legal notice was sent. And upon failure to pay the amount, the complaint was discharged. In order to prove the case, the complainant examined 2 witnesses, including himself as CW2. The check was marked as Exhibit 1. The return memo was marked as Exhibit 2. The legal notice dated 25/10/2007 was marked as Exhibit 3. The registered postal receipt was marked as Exhibit 4. And the acknowledgement card was marked as Exhibit 5. It was dated 29/10/2007. So far as the defense is concerned, no evidence was adduced. No evidence was adduced from the side of the defense. The witnesses were duly cross-examined. it was a specific case of the defense before the learned trial court that the complainant should have filed a specific performance of contract and that it was not proved that the money was given by the complainant to the accused in terms of the agreement for sale, and thus there was no debt or liability, and thus debt or liability could not be proved by the complainant against the accused. The learned court considered the materials on record and was of the view that the basic ingredients for constituting offence under section 138 of Negotiable Instruments Act were duly proved. The learned court also took into consideration the legal presumption in favor of the complainant in terms of section 139 of Negotiable Instruments Act and recorded that the accused has not been able to rebut the legal presumption and ultimately convicted the petitioner. The learned appellate court also considered the materials on record and upheld the conviction. This court finds that both the learned courts have considered the materials on record and have upheld the conviction of the petitioner for offence under section 138 of Negotiable Instruments Act and have passed orders for giving compensation to the extent of rupees 1 lakh against check amount of against dishonor of check amounting to rupees 80,000. This court is of the view that the argument of the petitioner that the complainant has not been able to prove legally payable debt is misplaced in view of the fact that there is a legal presumption in terms of section 138 of Negotiable Instruments Act, and it was for the accused to dispel the legal presumption even though on the touchstone of preponderance of the fact. The accused having failed to discharge his initial onus has been rightly convicted by the learned court. Accordingly, this court is of the further view that there is no scope for reappreciation of materials on record in judicial jurisdiction in absence of any perversity or material irregularity. No grounds for interference has been made out. Accordingly, this revision is hereby dismissed. Same ground?
Yes, will same everything same. Only amounts not 1,80,000 का है.
Heard the learned counsel for the parties.
No instruction में dismiss कर दिया गया है.
नहीं करेंगे. मजाक बनाते रहेंगे नहीं. आपको क्या लगता है? नो इंस्ट्रक्शन में डिसमिस कर दीजिए, उसके बाद फिर रेस्टोर कराते रहिए, उसके बाद घूमते रहिए.
एक बार वो भी चुका.
देखिए. Heard the learned counsel for the parties. आपका कोई सबमिशन रिकॉर्ड कराना है कि नहीं कराना?
Same
This-
submission. Same submission.
Same. Same submission record करेंगे. After hearing the counsel for the parties, this court finds that it was a specific case of the complainant, that the complainant had given advance money of rupees 1,80,000 to the accused for purchase of land. But the accused failed to execute the sale deed. The complainant demanded his money back, and then the accused had issued 2 checks dated 17/7/2010 for rupees 80,000 and rupees and 24/7/2010 amounting to rupees 1 lakh, both drawn on State Bank of India, which upon presentation were dishonored due to the reason insufficient fund. The check return memos were received by the complainant. Check return memos dated 17/7/2010 and 24/7/2010 were received by the complainant on 19/7/2010 and 26/7/2010. Subsequently, on the request of the accused, the complainant again presented the check, but the same was again returned with a note insufficient fund by return memos dated 19/8/2010, which was received by the complainant on 28/2010. And then the complainant sent legal notice dated 25/8/2010 to the accused through speed post. In spite of that, when the accused did not make payment of the check amount, the complaint was dismissed. The records reveal that in support of the complaint case, the complainant examined altogether three addresses. The complainant was examined as CW1. The checks were exhibited as Exhibit 1 and 1 by 1. The check return memos were exhibited as Exhibit 2 and 2 by 1. The subsequent check return memo was exhibited. ये ले लीजिए तो पैरा 6 से ले लेंगे है ना सारे एग्जिबिट्स. The complainant was duly cross-examined. The complainant had supported his case and he was duly cross-examined. And in his cross-examination, he had stated that he had not filed the agreement of sale, but the agreement of sale was duly prepared for the land situated in Khata number 291, plot number 1193, measuring 500 square feet. The other two witnesses, CW2 and 3, had fully supported the case of the complainant. And during cross-examination, they had deposed that the complainant had paid the money in advance. The defense did not lead any evidence. The learned trial court considered the materials on record and was of the view that the complainant has complied with all the necessary time limits which are required for prosecution under Section 138 of Negotiable Instruments Act. And held that the basic ingredients for offence under Section 138 of Negotiable Instruments Act were proved beyond reasonable doubt and convicted the accused. So far as the appellate court is concerned, the appellate court also considered the materials on record and upheld the conviction of the petitioner. This court is of the considered view that merely because the agreement of sale was not exhibited, the sale was not fatal to the case of the complainant in view of the legal presumption with regard to issuance of check. The records reveal that the petitioner, being the accused, did not take any step to dispel the legal presumption even on the touchstone of preponderance of probability. The issuance of check and its bounce stood duly proved. The argument of the petitioner that it was for the complainant to prove the legally payable debt in order to convict the petitioner is misplaced in view of the fact that, in view of the legal presumption drawn in favor of the complainant in terms of Section 139 of the Negotiable Instruments Act, this court finds that both the learned courts have considered the materials on record and has convicted the petitioner. The counsel for the petitioner has not been able to make out any ground to interfere with the impugned judgment of conviction of the petitioner for offence under Section 138 of the Negotiable Instruments Act. The scope of interference in revision jurisdiction is very limited. There will be no illegality, perversity, or material irregularity in the impugned orders of conviction. This court finds no merits. Accordingly, the petition is hereby dismissed.
Pass over case item 7, criminal revision 757 of 2016.
In this matter also notice was earlier issued to OP number 2.
File your surrender certificate.
The exemption has been allowed.
No. By which order it has been allowed?
On 20th November 2017.
Read the order.
Order is not available with me.
Until further orders, no coercive step is taken.
Not-
This is not an order allowing exemption. That IA is still pending. You file your exemption certificate.
Also, I am ready to deposit the amount before learned registrar. I am ready to deposit entire amount, 1,05,000.
That is the compensation amount. What is the compensation amount?
Therefore, 5,000.
Deposit by tomorrow.
I am ready to deposit.
जमा करिए.
ठीक, 2 हफ्ते बाद 2 हफ्ते के अंदर जमा कर देंगे. Complainant is not appearing in this matter, therefore compromise is not possible. Otherwise,
Complainant is not appearing, but the service report of the state says that the husband has been informed about it.
yes, and she, the husband has not disclosed with respect to
Her phone
whereabout of
number,
complainant. Whereabout of
Very
complainant.
well. Appoint an amicus for the complainant. Dispose of the matter. Complainant नहीं आएगा तो क्या करेंगे? केस थोड़ी पेंडिंग रहेगी.
ठीक,
अब पैसा जमा कराइए हाई कोर्ट में.
मैं जमा करा देते हैं.
15 दिन में या तो जमा करा दीजिए, तब आपको एग्जेम्पशन दे देंगे.
हाँ, जमा करा देते हैं. मेरा पार्टी से बात हुआ है.
Criminal revision number 757 of 2016 with IA number. ट्रैकिंग रिपोर्ट तो इसका है. स्पीड पोस्ट से आपको नोटिस हुआ था.
हाँ, बाद में. क्योंकि लास्ट डेट में हम अपीयर नहीं किए क्योंकि इंस्ट्रक्शन हमको नहीं मिल रहा था क्लाइंट का, पार्टी का.
IA नंबर कितना है?
आईए नंबर 4269 of 2016.
With IA number 4269 of 2016. The learned counsel for the petitioner has submitted that the interlocutory application seeking exemption from surrender was taken up by this court on 2011-2017, wherein the petitioner had expressed that the petitioner is agreeable to settle the matter with opposite party number 2 and deposit the entire compensation amount.
उसको भी
He
indicate कर
submits
दिया.
that on such submission, interim order of no coercive steps was passed in favor of the petitioner. He submits that notices were issued to opposite party number 2 and the concerned police officer had contacted the husband of the opposite party number 2 at the given mobile number, which has been mentioned in the service report, but the husband of the opposite party number 2 did not disclose any further about the opposite party number 2. He submits that the husband knowing the husband of opposite party number 2 is fully aware of the present case. But the opposite party number 2 is not taking any interest. The learned counsel submits that in such circumstances the case has to be argued on merit, and he is ready to deposit the amount of rupees 1,05,000 before this court.
1 लाख
1,05,000 before this court, and he may be exempted from surrendering before the concerned court. After hearing the learned counsel for the learned counsel on behalf of the state does not dispute that, in spite of best of efforts, the notice would not be ultimately handed over to opposite party number 2, but the husband of the opposite party number 2 is well aware about the present proceedings. यही है ना कहानी?
यही
Considering the aforesaid submission, IA number 4269 of 2016, seeking surrender,
exemption from surrender.
seeking exemption from surrender is allowed, subject to deposit of rupees 1,05,000 before this court in the following account. The petitioner is directed to file a supplementary affidavit disclosing the details of the deposit within the aforesaid period of 2 weeks. In absence of
Having the next
in
demand.
absence of in case the supplementary affidavit
3 weeks
for
कर
the
दिया है।
deposit is not filed, this case will stand dismissed without reference to the bench. The office shall prepare appropriate office note with regard to dismissal of the case and communicate to the court concerned to ensure that the petitioner serves the sentence.
और अगर जमा कर देते हैं तो नो पैसिव ऑर्डर विल कंटिन्यू.
Okay, exemption from surrender allowed तो कर दिए. Okay, let this order be communicated through fax.
3 weeks कर दिया है. 2 weeks में पैसा 2 weeks में ही हमको फाइल भी कर देना है.
2016 से यही कहानी चल रहा है.
नहीं कोई कहानी नहीं चल रहा है.
कहानी ही चल रहा है.
अब तक आई होती तो हम पैसा
खोज के
दिला
लेके
करके
आइए.
डिपॉजिट ही कर अब तक खत्म ही
हो सकता है फिर भी वो कॉम्प्रोमाइज ना करते.
नहीं
Possible.
पैसे के लिए ही लड़ाई का पैसा मिला. 3 weeks कर दिया.
2016 कब का चेक है? कब का चेक है?
2012 का तो केस ही है.
2012 का केस है ना, तो हो सकता है वो 1,05,000 में कॉम्प्रोमाइज ना भी करे. कौन जाने.
3 weeks कर दिया जाए. एफिडेविट फाइल करने के लिए
कुछ नहीं आता.
3 weeks
जमा
कर
करिए
दिया
और
जाए.
एफिडेविट फाइल. इंस्ट्रक्शन जब लेके आए हैं तो 1,05,000 रुपए हाथ में लेके बैठे हैं.
हम ये नहीं कर रहे. हम ये कर रहे हैं कि 2 weeks मेरा
इसका कोई बार्गेन का कोई बात नहीं है.
बार्गेन तो कर ही नहीं रहे हैं.
तो बस 2 हफ्ता दे दिए काफी.
मेरा सबमिशन ये है कि 2 हफ्ता के अंदर डिमांड ड्राफ्ट यहाँ जमा कर देते हैं.
डिमांड ड्राफ्ट नहीं जमा करना है, आरटीजीएस से पेमेंट करना है, थ्रू ऑनलाइन मोड कर दीजिए. और आदमी का आने का कोई काम ही नहीं है यहाँ पर.
नहीं, ठीक
आरटीजीएस से जमा करिए, एफिडेविट यहाँ फाइल करिए,
है, ठीक
हो गया, बात खत्म.
है, ठीक
आइए डिस्पोज.
है.
आइए डिस्पोज. इसको और एक रिकॉर्ड आ गया है ना.
हाँ रिकॉर्ड आ गया.
The records of the concerned court has already been received. Post this case under the heading for final disposal on (11th of September). In
Also-
case the order is complied, तो ऐसे DFD हो जाएगा.
Passover case item 9 criminal division 1205 of 2016.
बताइए क्या कहेंगे.
Conviction under 138.
138 with 420 दोनों में conviction है. 138. You are for
For the opposite party number 2 members are appointed amicus.
yes.
He's been appointed as amicus here. Thereafter, certain exercises were undertaken by the court. And she will find some report was invited. The complainant is not received. So on account of that,
Complainant
some
is not
complainant is not received.
not received.
Not received. And the court had asked the DLSA to find out and report. It was pending for that.
कंप्लेनेंट का क्या नाम है?
कंप्लेनेंट का नाम है
दर्शन सिंह
दर्शन सिंह मोंगा।
पंजाब चले गए होंगे। आपको इंस्ट्रक्शन कौन दे रहा है बहस करने के लिए?
हमको
मतलब you just have वकालतनामा and therefore you are arguing.
I am for the accused.
Sorry,
I am for the accused.
आप नहीं है दर्शन सिंह मोंगा?
No, no.
अच्छा, ओपी नंबर 2।
yes it's okay number
Darshan Singh Monga is the OP
अच्छा,
number 2,
OP
the
number।
complainant.
आपको इंस्ट्रक्शन है ना बहस करने?
जी जी।
बताइए।
सफिशिएंट इंस्ट्रक्शन नहीं है लेकिन है।
रिकॉर्ड है और क्या चाहिए?
Yes,
फाइल
yes।
है, वकालतनामा है,
नहीं,
इसके अलावा
हम
कोई
बाद में
instruction-
सीखे कि कोर्ट जब इंस्ट्रक्शन पूछती थी ना तो कुछ और नहीं होता।
ऐसी बात है। आप उनमें से नहीं है कि इंस्ट्रक्शन
Yes।
को पेंडिंग रखें।
Yes, grateful.
कितना हम लोग को पता है, आपका इंस्ट्रक्शन सब पेंडिंग नहीं रहता होगा।
Yes. Election straight away may come to the vital legal point before we go into the other portions of the record. Anita Hata.
Sorry?
Anita Hata, which laid down the law that without prosecuting the company, the director cannot be prosecuted vicariously. That position of law is applicable. The very complaint your edition will find. Just show 3 portions of the records to address this. In addition, please take the complaint. The admission is the opening page of the complaint.
लाइट है।
And my revision ground number T, which is at page 15 of the memo of revision.
I am at the complaint.
Yes. Darshan Singh Monga is the complainant. Name of accused Amar Priyadarshi. Director Vatan Desire Infotech Private Limited.
That's right.
Of course, in the original complaint, Vatan Desire Infotech Private Limited was also implicated as accused number 2.
That's right.
But no cognizance was taken against the company.
No cognizance was
Was
taken.
taken against it. And then again, your ladies will find at paragraph 3. Clear admission. Paragraph 3.
Just a moment.
Yes. One Taranjeet Kaur was running an institute. She wanted to close down. So our company wanted to purchase the furnitures. In connection with that, the price fixed was 13 lakhs and odd. And after few episodes of dishonor, ultimately checks were given in 2 tranches. One to the complainant and another to the nominee of the complainant. And it is the case is with regard to dishonor of checks given to the complainant. So with regard to that, paragraph 3, 15 December 99, the accused number 1 named.
Just a moment.
Sorry.
नहीं, ऐसा तो नहीं है कि सिर्फ एक ही के ऊपर हुआ कॉग्निजेंस, ऐसा नहीं है।
The charge is as against Amar Priyadarshi only.
We do not know.
And
The
he has been
cognizance
tried.
was taken against both. परिवार में नामित अभियुक्त के विरुद्ध भारत का इतना
उसको
मतलब
पूरा पढ़ने से
ऐसा कोई अभियुक्त के विरुद्ध है, कोई ऐसा कोई सिलेक्टिव नहीं है, अभियुक्त नंबर 1 के विरुद्ध बनता है, 2 के विरुद्ध नहीं बनता है, ऐसा कुछ काम नहीं है।
I am sure that the company is not being prosecuted.
अपील किसने फाइल किया है?
Okay.
Who filed the appeal?
The petitioner.
This revision jurisdiction.
And the company did not.
Although Milord's
Company
at
was
the
not convicted.
page 5 of Milord, the judgment of Milord, the learned judicial magistrate, Milord, find there is a statement that Milord, on 15/10/2001, after inquiry, learned court has taken cognizance against accused, namely Amar Priyadarshi, under section 138 of the NI Act and 406/420 of the IPC on 21/11/2003, charges framed under section such and such. So, from the judgment, it appears that the cognizance was only taken against Amar Priyadarshi. Although, my lords, in the complaint petition, if your lordships will see, the company was also made an accused through the director.
This is what I was pointing out. And I was so sanguine in making this statement because I see the charge is with me, 313 is with me. All that is only against Amar Priyadarshi. The trial starts by
It
charge.
says order taking cognizance is dated.
It's already the cognizance dated 15/10/2001. 15/10/2001.
2001.
Yes.
And it says that it is only against.
Amar Priyadarshi. Running page 25 of the revision bill.
Petition and not the company. 15/10/2001.
And charge was framed your leadership on 21st of November 2003.
21/11/2003.
That charge was only against Amar Priyadarshi.
There was a criminal revision number 77 of 2003. Before the learned ACJ, fast track court,
77 of
2003.
she has been able to
And
carry
thereafter
this.
a supplementary case record was opened. 77 of 2003. Not before this course, before the learned ACJ. AJC.
Your leadership has been pleased to gather this form.
From the order sheet. Charge 21/11/2003.
Your leadership, this order is of
Trial court
not date.
21/11/2003.
The date on which charge was signed. But ostensibly there could be no reason why company's trial will be separated. Individuals are not found and therefore separation of trial is ordered.
फाइल हुआ था शायद 420 वगैरह में भी कॉग्निजेंस हो गया था. Does the order says that the company is acquitted? या order बोल रहा है कि
company has not
cognizance
been
नहीं है.
tried. Company has been tried pursuant to cognizance taken against some creditors. For bringing home guilt, finding of guilt against somebody on account of vicarious liability, there has to be finding of guilt against the principally liable person. That is where the matter goes.
There was a rejection of discharge petition also on 35/2003.
Yes. Rejection of discharge has to precede framing of charge.
35. गलतनामा भी डायरेक्टर की तरफ से फाइल है. चलिए पढ़िए देखते हैं.
Yes. I would also invite your leadership to kindly look at 2 more pages.
The cognizance was taken against both. इसमें कोई doubt नहीं.
I acted on the observations made in the judgment.
That's it. आप देख लीजिए ऑर्डर शीट.
No, I'll take.
बताइए.
अच्छा पेज 3 एक बार दिखाएं.
Page number 3 of the trial court judgment.
Page number 3 of the complaint which I have shown. Just to corroborate whatever was shown in the first page.
Yes.
The title itself said director. 15 December 1999, the accused number 1 namely Amar Priyadarshi, director Watan Bizarre. So that's admitted by the complainant in the complaint. Now one thing is very important. The complainant's evidence as complaint witness number 2, CW2, that your addition may take the cross-examination, paragraph 3. Cross-examination dated 8th of June 2009, paragraph 3. That you ladies will find at first, second, third, fourth, fifth, sixth, seventh, eighth page. This deposition.
Of the complaint of the complainant. Which page are you reading? ऐसा सिलेक्टिव मत पढ़िए, बताइए क्या बताना क्या चाहते हैं उसके बाद हम बताएं. What do you want to
Message for
suggest?
parents. She will accept my statement.
Yes.
एज डायरेक्टर की हैसियत से कंपनी की तरफ से चेक अभियुक्त ने दिया. ये बड़ा वाइटल स्टेटमेंट. एकदम लास्ट लाइन, 8th पेज का लास्ट लाइन, जहाँ से क्रॉस एग्जामिनेशन शुरू होता है.
एट पेज बोल के कुछ है ही नहीं इसमें.
लीडरशिप इसका जो एविडेंस है,
क्रॉस एग्जामिनेशन देखते हैं इसका.
क्रॉस एग्जामिनेशन जो मिला
Complainant was examined as
CW2
CW2.
10th February 2002.
पैरा नंबर कौन सा है क्रॉस एग्जामिनेशन?
पैराग्राफ, इसका जो चीफ है, पूरा का पूरा चीफ एक पैराग्राफ में रन करता है. 1 2 3 4 5 6.
हाँ ठीक है,
सातवां पेज
ये
में
क्रॉस एग्जामिनेशन मुझे मिला. पढ़िए क्रॉस एग्जामिनेशन.
क्रॉस एग्जामिनेशन में सेकंड पेज पैराग्राफ 3.
हाँ पढ़िए.
पैराग्राफ 3 का लास्ट लाइन,
हाँ.
एज डायरेक्टर की हैसियत से मिला.
उन्होंने बिजनेस जानता हूँ, सरदार जी जो इंस्टीट्यूट किया था उसका डायरेक्टर है.
क्रॉस शुरू होता है उस पैराग्राफ 2 से, जो कागजात इस केस में दाखिल किया है.
तरनजीत कौर के पिता
पैराग्राफ 3 है, तरनजीत कौर के माता पिता ने. उसमें पैराग्राफ 3 देखिए, तरनजीत कौर के माता पिता ने.
हाँ हाँ ठीक है मिला.
तरनजीत कौर के माता पिता ने.
हाँ.
उस पेज का सबसे लास्ट सेंटेंस है.
हाँ.
एज डायरेक्टर की हैसियत से कंपनी की तरफ से चेक अभियुक्त किया.
एज डायरेक्टर की हैसियत से कंपनी की तरफ से चेक अभियुक्त.
So this vital fact stands admitted, which attracts what has been held by this honorable by the honorable Supreme Court in the heart. May I pass on this judgment? Right. Passes. In addition, by this judgment, I'm sure Your must have seen this 1,000 times. I'm just pointing out. By this judgment, conflict between different benches of the Honorable Supreme Court was set at rest. Paragraph 59 and 58 should suffice. In paragraph 58, your addition will find, applying the doctrine of strict construction, you have the considered opinion that commission of offence by companies and express condition precedent to attract the vicarious liability. I'll just stop here for a moment. So this condition precedent has to be recorded by somebody. That finding is required to be recorded that the offence has been committed by the company. And that finding by primordial principles of natural justice has to be done in the presence of the company, against whom the finding is being recorded. Thus, the words as well as company appearing in section make it absolutely unmistakably clear that when the company can be prosecuted, then only the persons mentioned in the other categories could be vicariously liable for the offence subject to amendments in the petition and proof. Amendments and proof I am not going into for the time being. Then Your Lordship kindly go to paragraph 59. In view of the aforesaid analysis, we arrive at the irresistible conclusion that for maintaining the prosecution under section 141 of the Act, a arraigning of a company as an accused is imperative. That was initially done. The other categories of offenders can only be brought in the dragnet on the touchstone of vicarious liability, as the same has been stipulated in the provision itself. Your Lordship, this was a case where Poshmet was inconsidered. We say so on the basis of the ratio laid down in CB Parekh, which is a 3-judge bench decision. Thus, the view expressed in Shivrat and Agarwal does not correctly lay down the law and accordingly is hereby overruled. The decision in Anil Hada is overruled with a qualifier as stated in paragraph 51. The decision in Motor Discipline has to be treated with restricted to its own facts, as has been explained by us therein.
That's right.
So this judgment has been followed so many times. One more judgment I want to point out for yet another important aspect. I think this is an important aspect. This SMS Pharmaceuticals, which is a judgment which Anita Hada has also relied upon. Paragraph 19, last line, is helpful in the sense that it clarifies that the person who signs the check. Your Lordship, I was wondering, within myself, I was analyzing this aspect as to what happens. Suppose the company is the drawer of the check. It does not have its hand and legs and mouth, so it does it through the hands of a director or any person authorized. Now there may be two kinds of directors: one who has signed it and others who have not signed it. So whether this Anita Hada ruling, the benefit will flow only to the person who has not signed it, and the person signing it, I was wondering within myself whether the person signing should be treated as directly liable. So to rule that out, I was analyzing, and section 138 is direct liability, 148(1) is vicarious liability. So this judgment, the paragraph 19, the one which I passed on, paragraph 19, last sentence makes it clear that the person who is signatory to the check as director is to be held liable by virtue of 141 subsection. So it is 141
Check
only.
was issued in the company's account.
Yes, and section 138 says a person. Can you see the language of section 138?
No, there is no doubt on this
Yes.
proposition.
As against account maintained by him. It was an account maintained not by Amar Priyadarshi, it was an account maintained by company. Therefore, Your Lordship, ground number T of my revision is devoted to this aspect. And all other arguments may take a backseat. And one judgment of this Honorable Court, recently in a revision, a coordinate bench of this Honorable Court has considered Anita Hada and allowed the revision. Paragraph 38.
Paragraph.
Paragraph 30. Relies on Anita Hada and acts on that proposition and eventually concludes. Your Lordship, I don't wish to multiply authority, but just to state the latest position, one of the latest judgments is also Dilip Hariraman. This judgment, if Your Lordship sees, Dilip Hariraman. 2022 SCC Online SC 579. This judgment takes note of all the previous judgments. Of course, it's a two-judgment judgment. It has to accept what the three-judge bench has said in Anita Hada. Your Lordship, just note the paragraphs if Your Lordship so likes. Paragraph 9 is about burden of proof in case of vicarious liability. Paragraph 12 is also with regard to burden of proof on vicarious liability and the very celebrated judgment of Harmeet Singh Pendle has been made. Paragraph 15 and 13 refers to Dale D'Souza, Anita Hada and Gindhari Lal.
Let us see the findings. How does the court has sustained the finding of this debt?
The court has gone into only the aspect as to my denial that the person, there was no legal liability. Virtually, that was the factual argument that the person to whom check was given, my 313 also explains that he had no authority to, it was for sale of certain articles. So he eventually said that he had no authority to sell the articles. He had no right over the articles of the company which was owner of the article. That was all belonging to the company run by Taranjeet Kaur. So and we said that we check हमसे ढक के ले लिया था. बाद में हमको पता चला कि उसको कोई अथॉरिटी नहीं सब सामान का हम लोग चेक करो. Did she see the trial procedure?
नहीं,
And written is trial.
appellate.
Paragraph 15. In this way, after conclusion of the report, it is clearly that all dishonored check issued by Amar Priyadarshi appeared in due course of the above three checks are dishonored. Simply Reliance One has been placed upon that. In fact, appellate judgment is not very happy. It is just kind of a formal approval of the trial. Paragraph 16. In fact, your leadership in paragraph 5 of his cross-examination is gone to the extent of admitting that he never gave a notice also to Amar Batan Desire Private Limited.
Miss, what do you say?
Looks.
Your leadership, may I just invite you? She will kindly tell you paragraph 5 of the cross. I just read it. Amar Priyadarshi, तीनों चेक का नोटिस एक बार में ही दिया था. After he narrates the check dishonorable. नोटिस एक बार में दिया था. अमर प्रियदर्शी को उनके आवासीय पता पर तो अमर प्रियदर्शी को डायरेक्टर ग्रुप के प्रधान टावर में दिया था. वर्तन डिजायर इन्फोटेक प्राइवेट लिमिटेड को हमसे नोटिस नहीं दिया था. So dishonor of check with regard to dishonor of check, unless we really accept that the notice to director amounts to notice to company, then matter would be different. I just
This
wanted
para
to
number?
This paragraph 5.
Paragraph 5 of cross-examination of
Complaints. The rest are not relevant. Complainant's evidence is sufficient. Because the line of cross-examination shows what was our defense. The property belonged to the company which was run by Taranjeet Kaur.
Where is the finding recorded that cognizance was taken only against the
Trial court's
One
judgment,
accused.
It's page number 5 of the trial court judgment.
that's
Can you
running page 25.
Running page 25 of the
Can you read it?
Milords. On 15/10/2001, after inquiry, learned court has taken cognizance against the accused, namely Amar Priyadarshi, under section 138 of the NI Act and under section 406/420 of the IPC. On 21/11/2003, charges framed under section 138 of the NI Act and 420 of the IPC. As per the judgment of the learned trial court, it says
Order
that
sheet दे दीजिए 15/10/2001
जी.
This order shows, your ladyship, if I may say so, that the magistrate was not even alive of the fact that there were two accused.
That's right. But it does not say that the company is absolved, no
He
case
does
is
not
made out again.
He
says
says
that
अभियुक्त तो बोलता,
named accused in the complaint.
अभियुक्त
हम
means
उसको
what?
मान लेते हैं कि अभियुक्त लिखा है, अभियुक्त लिखा है,
अभियुक्त लिखा है और बाकी कुछ दिमाग में लगाया है।
capable of being, yes.
लेकिन ऐसा नहीं है कि by this order we can gather that the cognizance was taken only against the
Eventually,
Accused number
your
two
ladyship,
and not
usually
against
issues on
accused.
that, this position of record. Eventually, there has to be trial and conviction and finding of guilt against the company.
that's
That is what is important, which is not the case. Admitted in the position of record. Trial is only against some privilege. Finding of guilt is only against him. There is no advertence to this aspect.
yes. What do you have to say?
What I could gather from the order taking cognizance is that it has been stated that the cognizance is taken against the named accused persons in the complaint. Although there are two accused, and so far Amar Priyadarshi is concerned, he has also been made an accused in the capacity of director of the company, not in personal capacity. If will see in the complaint petition, Amar Priyadarshi, son of such and such, director.
See, the law is well settled
My
that
lords.
that so far as the director of the company is concerned, you see there could be a situation where a director who is otherwise a bankrupt, right, is issuing checks of crores of rupees from the company's account. Possible?
Yes.
So therefore, the liability of a director, the liability of a company, they stand on a different footing altogether. The records indicate that the transactions were with the company, right? And ultimately, the courts have not convicted the company. Even if we take it that cognizance was taken, the courts have not convicted the company. The courts have only convicted the director. How do you justify that?
So far, this part
Without
is concerned.
convicting the company, can the director be convicted in connection with a check issued on behalf of the company?
That can't be done, but
That can't be done. Then how do you sustain $19?
I'll
And your ladyship, from the records, the check also signature.
Yes, yes, I've
उसके
seen that.
नीचे, yeah, for and on behalf.
for that is
But I've
admitted in
seen
the
checks
cross
सबसे पहले
examination
उसी को
also.
देखते
वही उनको दिखाना चाहिए.
That has been admitted by the complainant also in the cross examination. But may I just point out, in the trial court as well as in the in the appellate court, this ground was never taken. The
How
only
does that make
contention
any
from the judgment, what I could gather, in the finding portion itself, it is, may I just point out, page number 9, of the trial court judgment.
You see, the accused is continuously taking a plea that he had no control over the institute.
That was the only contention.
So
as
institute
per
was
the-
belonging to the company. That is why he is taking a plea that he has no control over the institute.
The institute was earlier run by two persons, out of which one died. And thereafter, what has been stated in the complaint petition is that due to old age, this opposite party number 2 was not in a position to run that institute, and therefore he wanted
I
to
must
sell the.
clarify, ladyship, even if it goes against me, I must clarify one fact. To my understanding, when accused is saying no control, he is perhaps talking about the complainant with regard to the beneficiary of the checks.
para 2 of the complaint, my lord, that
He has continuously taken the plea. Hiradishu is right. He has taken continuously the plea that the person who had taken the check had no control over the property or any right over the property belonging to that company whose article we wanted to purchase.
Let me hear him, don't disturb him, right?
I'm sorry.
It's paragraph 2 of the complaint, my lord. It has been stated that after death of Miss Taranjeet Kaur, who was the partner of this
Partner
opposite
or
party,
director?
my lord, she was running the complainant was running the institute along with Miss Taranjeet Kaur. That is there in the complaint petition.
As director?
No, my lord, not as a director. They were taking care of the institute. Thereafter, my lord, it has been stated that after the death of Miss Taranjeet Kaur on 19/5/1997, the complainant started facing difficulties in running the said institute because of his old age and ailments. And thereafter, he wanted to, my lord, sell the furniture and the fixtures, and thereafter, my lord, the transaction took place. And my lord, so far, my lord, this finding is concerned by the learned trial court, my lord. My lord will see, my lord, page number 9 of the trial court judgment. It has been held, my lord, that in the statement under section 313 of the CRPC, the accused has admitted that he has issued the checks in question. It is further submitted that the complainant has no right over the checks because he was not the owner and oblique partner of the said institute. He has not denied the documents which were marked as exhibit. Under such circumstances and discussions made over there is nothing on record to disbelieve the case of the complainant. Accused himself is not able to prove his innocence. Complainant has proved his case under section 138 of NI Act with oral as well as documentary evidences. The main contention of the accused is that the complainant has no right over the institute. This contention is not material because no objection made by the parents of Taranjeet Kaur regarding the institute. From the above discussion made over, I come to the conclusion that the complainant has proved his case. So, my lord,
We don't get it. What does that mean?
my lord, what I am trying to say is, my lord, this ground was never taken.
Right. Is this ground was never taken? But is there any estoppel?
No estoppel, but my lord, under revisional jurisdiction, my lord, can my lord remand this matter back to decide on that particular point, that whether the cognizance was taken or not. Because if my lord, on the face of the record, my lord, if it is found that the materials have not been appreciated, then my lord, can my lord remand this matter. My lord, as per the judgment passed by the
Because the
Honorable Supreme
cognizance
Court.
order is not speaking that cognizance has been taken
Therefore,
only
because it
against
says
one.
that against the named accused person, not persons, person. But there are two named accused persons in the complaint.
And cognizance is always of the offence.
But what my learned senior has argued, I cannot, because that is a settled proposition of law. If the company is not prosecuted, then
In your cross-examination, you have stated that it was a partnership firm. Yes, Darshan Singh Monga in his cross-examination states that it was a partnership firm.
the institute,
About themselves.
Partnership registered नहीं था.
the Taranjeet Kaur and this opposite party member, although it was not registered, but
No, Taranjeet Kaur and
the complainant, the opposite
complainant, they entered into a partnership agreement.
party. Perhaps verbal, because that was not
Verbal
registered.
maybe.
My lords.
So, the complainant entered into some kind of transaction with this Paramjit Kaur in the capacity of a director of a company.
It's not with Taranjeet Kaur. Taranjeet Kaur was the partner of this opposite party number 2. Therefore, my lords, the check was issued in 2 names. One in the name of this complainant and other in the name of the nominee. Because the other partner, Taranjeet Kaur, she was no more.
No, I am not able to get it. There are 2 accused in the case.
Yes.
One is the director and the company,
Yes.
right? Director is accused number 1
My lords.
and the company is accused number 2, right? Paramjit Kaur was the director of accused number 2.
No, my lords. My lords, Taranjeet Kaur was the partner of this complainant. Taranjeet Kaur and Darshan Singh Monga, who happens to be the opposite party number 2, they both were running an institute.
Okay.
And my lords, after the demise of Taranjeet Kaur, what has been stated in the complaint petition, my lord, that this opposite party number 2 started facing difficulties in running that institute. Therefore, my lords, he offered to sell this institute, the fixtures and the furnitures to the accused, my lord, the accused company and the accused person. And thereafter, this transaction took place. So far the cross-examination is concerned where he is admitting that this was a partnership firm. He is intending to say that the institute which they were running was a partnership firm, although the partnership was not registered.
The check was certainly issued from the account of a company.
Yes, that is there. Because in the cross-examination also the complainant has admitted as director issue kiya tha, which my eminent senior has.
There is a serious error of record, Mr. Pani Neeraj Rai, with regard to order taking cognizance.
Your Lordship, the trial commences by framing of charge.
That's right.
There is no charge and no trial. And in any case, the complainant is not receivable. Our case was irreligible, just to clarify. This check was given for purchase of certain furnitures which were in that institute. And this man seemingly portrayed himself as having authority over that institute and furniture, which we discovered that he did not have. It was all belonging to Taranjeet Kaur. So in his cross examination, he says स्वतः कहते हैं agreement हुआ था, मतलब तरनजीत कौर के साथ आपका क्या relationship है, so that he could have some authority to receive the check, so that there could be some legal liability in discharge of which the check could be said to have been given.
What was the reason for dishonor of check?
We realized that this person is not having authority.
The
over-
reason for dishonor of check?
Stop.
Stop payment.
एक
Flag दीजिए। अच्छा ये है।
exceeded arrangement. Paragraph 3 and 2 of the cross examination are very important here. Paragraph 3 says तरनजीत कौर के माता पिता ने इस केस से संबंधित चेक की बाबत मुझे अभी तक अथॉरिटी नहीं दिया है, गवाही में भी नाम नहीं दिया हूँ। हरेंद्र सिंह जग्गी के फर्नीचर इंस्टीट्यूट का बनाया था, उसे फर्नीचर बनाने का पेमेंट हुआ। Case of the complainant is that the total deal was for 39 odd lakhs. And eventually I was asked to give 7 lakhs check to Harinder Singh Jaggi and 6 lakhs to this gentleman. And dishonor has taken place with regard to 6 lakhs given to this gentleman. And he admits, paragraph 3 third line, हरिंदर सिंह जग्गी के फर्नीचर इंस्टीट्यूट का बनाया था उस फर्नीचर बनाने का पेमेंट उसे हो गया, वह चेक अमर प्रियदर्शी ने दिया। इस शूट के मकान मालिक से मेरा कोई लिखा पढ़ी नहीं हुआ, अभी ऊपर हम लोगों ने फर्नीचर दिया, फर्नीचर जिसने बनाया था उसको उसका पेमेंट मिल गया 7 लाख, और इसको भी 6 लाख दिया था, वो चेक डिजर्व। Our case is that we have realized that we have no authority over the property for purchase of which the checks were given. All said and there has to be a legal liability for which the check should be given.
इन सब केस को रिमांड कर क्या?
I don't think it should be because even alive.
Because 97 में वो कह रहे हैं कि due to old age he was facing difficulty, the complainant, in running the institute. More than 27 years ago.
कोई पर्पस नहीं, these are all burden to the system, unnecessary. चेक वही है ना, तीनों कंपनी की तरफ से इशू है। और the learned counsel for the parties, criminal revision number 1205 of 16. The learned counsel for the petitioner, while assailing the impugned judgments, has submitted that the complaint was filed against the company and its director in connection with bouncing of check issued by the company under the signature of the director, the petitioner hearing. He has submitted that the charge was framed for offence under section 420 IPC and 138 of Negotiable Instruments Act only against the petitioner. And ultimately, the petitioner has been convicted only for offence under section 138 of Negotiable Instruments Act and has been acquitted for offence under section 420 of IPC. The Learned Council submits that the checks were issued for discharge of liability of the company, though under the signature of the petitioner, but in absence of any charge having been framed against the company, the conviction of the petitioner for offence under section 138 of Negotiable Instruments Act cannot be sustained in the House of Law. The Learned Council has referred to the judgment passed by Honorable Supreme Court in the case of Anita Hada versus Godfather Travel and Tours Private Limited, reported in bracket 2012 bracket close 5 SCC 661. And has submitted that it has been finally held that the prosecution against the director or authorized signatory of the check without arraying the company as an accused is not maintainable. He submits that in the present case, though the company was made a co-accused along with the petitioner, but neither any charge was framed against the company nor the company faced the trial accordingly. He submits that the company having not been proceeded against by the concerned courts, by the trial court, there was no occasion to convict the petitioner, who was admittedly a director of the company and had issued the check in the capacity of the director of the company. The Learned Council submits that the vicarious liability cannot be fastened upon the petitioner in absence of conviction of the company as well. Correct?
Yes.
जब तक उनका conviction नहीं होगा, vicarious liability भी
Finding
नहीं आ
of
सकती.
guilt.
The Learned Council, by referring to the evidence of the cross-examination of the complainant, has referred to paragraph 3 and has submitted that the complainant has specifically stated that the accused had issued the check to the complainant in the capacity of director of the company. The Learned Council has also relied upon the judgment passed by the Honorable Supreme Court, reported in 2022 SCC Online SC 579. and has referred to paragraph 16 thereof to submit that the provision of section 141 of Negotiable Instruments Act imposes vicarious liability by deeming fiction, which presupposes and requires the commission of offence by the company or the firm. And unless the company or the firm has committed the offence as a principal accused, the persons mentioned in subsection 1 and subsection 2 would not be liable and convicted as vicariously liable. The learned counsel submits that the checks having been issued on behalf of the company under the signature of the petitioner being a director, the company having not been convicted, the conviction of the petitioner also cannot be sustained in eyes of it. The learned counsel appearing on behalf of the learned amicus representing opposite party number 2 has opposed the prayer and has submitted that this point was nowhere taken by the petitioner before the courts concerned. However, the submissions as advanced by the counsel for the petitioner by referring to the materials on record, particularly the fact that no charge was framed against the company, and also the fact that during cross-examination the complainant had specifically stated that the checks were issued by the petitioner as a director of the company are not in dispute. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that the complaint case number 256 of 2001 was filed against 2 accused. इसमें से कोट कर रहे हैं, ठीक है? अमर प्रियदर्शनी ऐसा करके 1 and 2. Admittedly, the accused number 2 was the company. The alleged offence and the petitioner, the accused number 1, was the director of the company. The alleged offence was under section 420, 406 IPC and section 138 of Negotiable Instruments Act. The specific case of the complainant was that the complainant along with one Miss Taranjeet Kaur was running a management institute in which they invested amount through different agencies, and the institute was well furnished and well equipped. After death of Ms. Taranjeet Kaur on 19/5/1997, the complainant started facing difficulties in running the institute because of his old age and ailments, and consequently thereafter on 15th of December 1999, the accused number 1, that is the petitioner, being the director of the accused number 2, approached the complainant with an offer to buy the furniture, fixtures, fittings, etc. for a total consideration of rupees 13.5 lakhs, to which the complainant agreed. And thereafter the accused number 1 paid a sum of rupees 20,000 as advance, 10,000 towards miscellaneous expenses, and handed over 3 post-dated checks for rupees 6 lakhs, 5 lakhs and 2,30,000 dated 10/1/2000, 30/1/2000 and 10/2/2000 respectively, drawn on Bank of India. It was these checks which had bounced, which led to filing of the complaint case.
May I just point out, perhaps these checks got lapsed. Thereafter, the accused issued 2 fresh checks.
All right. It further, ये मत लिखिएगा. Thereafter, the fresh checks were issued in the month of August 2000 to the extent of rupees 7,50,000. In the name of Harinder Singh Jaggi for the amount of rupees 6 lakhs.
7,50,000 was Harinder Singh Jackie.
Okay, 7,50,000 to Sir Harinder Singh Jaggi and rupees 6 lakhs in the name of the complainant.
Those are dated 5th of September 2000, 6th of September 2000 and 7th September 2000.
3 checks है कि 2 checks?
3 checks, 2 lakhs each.
अच्छा. The amount of rupees 6 lakhs was through 3 post-dated checks dated 5/9 of 2 lakhs each, dated 5/9/2000, 6/9/2000 and 7/9/2000. It was these checks which were dishonored on account of insufficient fund in the account of the company. The reason for dishonor was exceeds arrangements. These checks were again presented and again they bounced on account of insufficient fund, and ultimately the complainant issued legal notice by registered cover, and when the amount was not paid, the complaint case was lodged against the company as well as its director, who were made accused number 2 and 1 respectively in the complaint case. This court finds from the record that the charge was framed only against the accused number 1, that is the director of the company, who faced the trial and was convicted. The fact is that neither the charge was framed against the company and nor the company faced the trial, and in such circumstances the only point which calls for consideration is as to whether the conviction of the petitioner, who was the director of the company, can be sustained without the company having been convicted in the case. In view of the judgment passed by the Honorable Supreme Court in the case of Anita Hada, this court is of the considered view that it has been clearly held, considered view, it has been clearly held that commission of offence by company is an express condition precedent to attract the vicarious liability of others. And the word as well as the company appearing in section 141, 141, na?
Yes.
141 of Negotiable Instruments Act makes it absolutely unmistakably clear that when the company can be prosecuted, then only the person mentioned in other categories could be vicariously liable for the offence, subject to averment in the petition and proof thereof. Paragraph 58 and 59. सबका same view था? It was a common judgment of all the judges?
Yes.
58 and 59 of the aforesaid judgment is quoted as under. In the judgment passed by the Honorable Supreme Court, reported in 2022 SSC on line 579, in paragraph 16, paragraph 59 and 16, it has been held as follows. Considering the aforesaid judgments passed by the Honorable Supreme Court, it is amply clear that if the check is issued by a person in the capacity of the director of the company and the check is drawn on the company, then the conviction of the director cannot be sustained in absence of conviction of the company. The question of liability of the director arises only in the capacity of vicarious liability, provided the company is also held liable for offence under section 138 of Municipal Instruments Act. The company having not been proceeded, there was no occasion to convict the company, and consequently it was only the director of the company, who is the petitioner before this court, who has been convicted in connection with bouncing of check issued as director of the company. In view of the aforesaid facts and circumstances, this court is of the evidence as pointed out by the learned counsel by the petitioner, which has come up in the cross-examination of the complainant, clearly indicates that the complainant had categorically mentioned that the checks were issued as in the capacity of the director of the company. Considering the totality of facts and circumstances of this case, and after carefully going through the records, this court is of the considered view that the conviction of the petitioner, who was director of the company and had issued the check in the capacity of the director of the company against an account maintained by the company, his conviction cannot be sustained in the eyes of law, as the company has not been convicted, though the company was made a co-accused in the complaint case and no charge was framed against the company. Consequently, the ensuing judgments the fact it is not, there is no doubt that the petitioner had not raised such point before the learned court, but the aforesaid points being pure question of law, and it touches upon the rights and liberty of the petitioner, who had admittedly issued the check as a director of the company, can certainly be considered by this court on account of the aforesaid admitted facts of the court. एक appreciation इनका आप kindly raise your bill. प्रो बोनो नहीं होता है, सरकार को प्रो बोनो की जरूरत नहीं। अगर आप अपना बिल रेज करेंगे, we will feel honored. एक पैराग्राफ इनका appreciation का.
The judiciary may also take note of the content of the check for and on behalf. The judiciary was referred to the admission in cross-examination. That's also corroborated by.
This court has also seen the original check, which is available on record, which itself indicates that the check was issued under the signature of the petitioner in the capacity of the director of the company.
For Watan Desire. For करके लिखा.
That is enough.
Yes.
And the account was of the director of the company.
Much obliged.
ट्रायल कोर्ट ने बहुत बड़ा एरर किया है इसमें.
लिखा ठीक से नहीं.
नहीं, ये जो
मेरे पास
एक ही के अगेंस्ट में चार्ज किया ना, वो गलत ही किया.
नहीं तो उसको नोटिस ही नहीं दिया था ना कंपनी को.
हाँ, इसीलिए नहीं किया.
उस पर जा नहीं रहे हैं, लेकिन दिस इज व्हाट कंपनी को जो स्टैट्यूटरी नोटिस है वो तो जाना चाहिए, कंपनीज एक्ट के हिसाब से जाना चाहिए, कैन बी लेफ्ट एट द ऑफिस, कैन बी
That's
गिवन टू द डायरेक्टर,
Fair enough. I'm keeping these judgments.
प्लीज.
Allowed. Huh?
So I have to intervene before that one revision my lord Roshan has passed an order to surrender by today itself. I have filed an IE matter.
आइए आगे.
Yes sir, I have IE has been filed.
नंबर हो गया आइए.
Yes ma'am.
आइए नंबर क्या है?
911.
फाइल आया है इसमें? फाइल मंगाया? भी फाइल मंगाइए. मंगाइए. तो रुक जाइए. ऑर्डर करके ही उठेंगे. फाइल मंगाइए. नोटिफाई जो भी करना है करिए. भेजिए किसी को यहाँ से.
Item 12, Premium Division 1270, 2016.
The order is preemptory expiring today.
Today itself.
Have you mentioned it in
Yes
your
ma'am.
mention slip?
I mentioned.
हाँ बताइए.
Four, which has been convicted for the offence under section 440 IPC, and for 2 years, and the petitioner prefer appeal before the legislation shall have been confirmed. The point of during trial, he was in jail about 24 days, and in the Honorable High Court about 18 days.
लोहा पकड़ा है. लोहा.
मतलब
लोहा
लोहा
पकड़ा है.
ऑल्दो की कोई रिपोर्ट 414 का कोई थेफ्ट रिपोर्ट नहीं है.
Not required. 414 में कन्विक्शन करने के लिए थेफ्ट रिपोर्ट की कोई जरूरत नहीं.
आयरन को एक्सपर्ट के पास नहीं है.
Not required.
2010 में केस है.
414 दिखाए हैं. IPC. कितना का था?
जो
सामान कितना था?
सामानों का 10 टन.
तो कितना का? 10 टन का कितना वैल्यू होता है? बताइए. आपके अगेंस्ट में दूसरा कोई केस भी है?
जजमेंट को जरूर आया है.
और भी केसेस हैं आपके ऊपर? दो जने थे. ये दो केस होना चाहिए, एक ही केस है?
2 ट्रक्स वर
दोनों आप ही का था?
नहीं, हमारा एक.
दूसरा का क्या हो?
दूसरा कहीं क्रिमिनल पेपर पे ऑल्दो द 2 पर्सन्स वर ट्राइड.
दूसरे का बताइए क्या हुआ?
उसका तो पता नहीं.
ऐसे आप पता नहीं है बंदा बोलिएगा तो बहुत मुश्किल है. हाँ, आइडेंटिकल फुटिंग पर है, डिफरेंट ऑर्डर हो जाएगा, चलेगा?
वो लगता है कि वो फाइल नहीं है सारी इन्फॉर्मेशन.
दो 2010 का केस है, कन्विक्शन 2016 में हुआ, राइट? आपके ट्रक के ओनर हैं,
और
ड्राइवर भी हैं,
जी
ड्राइवर भी आप ही हैं।
नहीं, ड्राइवर अलग है, रोशन कुमार है। एविडेंस में कि देखने में लगता है कि अरेंज है।
आप क्या बोले, आयरन नहीं है?
लोअर कोर्ट में कंडीशन क्या है कि आपको प्रूव करना है कि वजन भी नहीं।
भाग रहा था आपका ड्राइवर, ड्राइवर को क्या हो, परमानेंटली भाग गया? ड्राइवर का क्या हुआ? ड्राइवर भी तो कोई एक्यूज रहा होगा,
जी
क्या हुआ उसका?
तो उसका ट्रायल
हम्म?
ट्रायल्स का फीस ट्रायल
भाग गया परमानेंट। ट्रायल ये ड्राइवर का कैसे सेपरेट हुआ? कुछ तो होगा ना, ट्रायल ड्राइवर का कैसे सेपरेट हुआ? आपको MMRD में कैसे छोड़ दिया? So it can be taken only on the basis of complaint. Forest Act में भी छोड़ दिया, उसको नोटिफिकेशन नहीं है. Ultimately convicted under section 414. पुराना कोई आपका है क्या केस?
ड्राइवर अभी फरार है.
क्या करना मैडम बताइए. Yes, tell us.
Convicted under section 449, which is for assisting in concealment of stolen property.
That's right.
And
They did not have the proper paper.
they did not have the proper class. And witnesses have
Seizure has been proved.
Seizure has been proved.
That's right. But they were not the persons who were driving the vehicle.
They are the owner.
They are the owners of the vehicle. Can something be considered on the point of sentence? They have been sentenced for 2 years,
2 years.
which is the maximum sentence under 414.
May extend to 3 years or with fine.
May extend to 3 years.
Or with fine or with both. Fine is also there.
414.
414.
Extended to 3 years.
May extend to 3 years. May minimum नहीं है.
Okay. May extend to 3 years
Or
or
with
with fine or both. Right. फाइन लगा देते हैं,
Fine लगा
सेंटेंस
दो.
कम कर देते हैं, सेंटेंस आधा कर देते हैं और फाइन लगा देते हैं. हो जाएगा? बताइए.
फाइनल तो थोड़ा बेसिक रहती है.
फाइन कैसे लगा दें?
है?
आपका बहुत ही कम कस्टडी हुआ. लोहा का चोरी में हाथ बहुत काला होता है.
ड्राइवर गलती करता है फिर आप
बिना आपके चाहे ड्राइवर थोड़ी गलती करे. 24 दिन और 18 दिन, 1 महीना 1.5 महीना हुआ बस. लेस देन 1.5 months. दस टन लोहा का कितना दाम होगा? तो आइडिया है?
Iron ore. It is iron ore.
आयरन ओर है.
Iron ore. That will be costlier.
एक साल से कम नहीं करेंगे. बाकी आपका फाइन 30,000. ठीक है. और आप अगर बहुत गरीब आदमी हैं तो आपने जेल में रह के सजा काट के 2 रुपया रोटी खाइए. रोटी की कमी नहीं है जेल में. देखिए
ड्राइवर वैल्यू सब खत्म हो गया.
हाँ,
ड्राइवर वैल्यू सब खत्म हो गया. आपको नौकरी कर रहे हैं लेबर.
खत्म हो ही गया होगा एक भी केस में पकड़ा जाने से. 2010 का कन्विक्शन है.
कन्विक्शन भी 2016 का है.
हाँ, लेकिन
2010
इंसिडेंट
का।
2010 का. और तो कोई केस नहीं आपके अगेंस्ट में एज पर द इंप्रूव्ड ऑर्डर.
जी.
क्रिमिनल रिविजन नंबर 1270 ऑफ 2016. हर्ड द लर्नड काउंसिल फॉर द पार्टीज. आपका कन्फाइन कर लें उसमें सेंटेंस में.
फाइन में 1 लाख रुपए काम कर लिया.
पीरियड अंडरगॉन तो फिर भी नहीं होगा. बहुत कम सेंटेंस.
नोट वुड एडिट कर सकते हैं कल।
अब कुछ नहीं। देखिए, for the learned counsel for the parties, this revision has been filed against the order dated judgment dated 22/6/2016, passed by learned sessions Judge West Singhum at Chaibasa, whereby criminal appeal number 23 of 2016 has been dismissed. The petitioner has been convicted by judgment dated 11/2/2016, passed by learned SDJM Sadar Chaibasa in connection with Jinkpani PS case number 8 of 2010, corresponding to GR case number 174 of 2010. The petitioner has been convicted and sentenced for offence under section 414 of Indian Penal Code, and he has been sentenced to undergo rigorous imprisonment for 2 years. The learned counsel for the petitioner has submitted that though the petitioner has been convicted for offence under section 414 IPC, but there was no theft report in connection with the articles which are said to have been recovered from the truck of the petitioner. The learned counsel has further submitted that the petitioner was not driving the vehicle. The vehicle was being driven by the driver, who are the main culprit in connection with the recovery of iron ore in the truck. The learned counsel submits that the petitioner has been punished for rigorous imprisonment of 2 years, and the petitioner has faced a criminal case since 2010 and more than how many years? 14 years. 14 years हो गया. More than 14 years have elapsed from the date of the incident, and the incident is of 10/4/2010. The learned counsel submits that some sympathetic view may be taken and the sentence be reduced. There is no minimum sentence as specified under section 414 of Indian Penal Code. The learned counsel appearing on behalf of the state has opposed the prayer and has submitted that in order to convict a person for offence under section 414 IPC, there is no need to have a theft report. The ownership of the vehicle with the petitioner is not in dispute, and the seizure was duly proved by concurrent findings recorded by both the courts. The learned counsel submits that the petitioner cannot be absolved of his liability under the provisions of Indian Penal Code. So far as the sentence is concerned, the learned counsel submits that it is for the court to consider the same, but considering the nature of offence, some heavy fine amount be also imposed against the petitioner. She has referred to section 414 of IPC and submits that the maximum sentence is 3 years with fine, 3 year or fine or both. It is all clear. The counsel for the petitioner has also submitted that the records indicate that there is no criminal antecedent against the petitioner. सही है ये?
one criminal sentence.
है?
Earlier he was involved.
कहाँ पर है? ट्रायल कोर्ट का जजमेंट में तो
कहीं पर है।
fail to prove any previous conviction. कहाँ से आप बोल रहे हैं? कहाँ से बोल रहे हैं? कुछ है इंस्ट्रक्शन आपको? तो दीजिए लास्ट। हाँ?
जजमेंट के मुताबिक
ये लास्ट सेंटेंस छोड़ दीजिए। कन्विक्शन तो नहीं है जैसा ट्रायल कोर्ट का जजमेंट।
कन्विक्शन नहीं।
After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that both the learned courts have found that the vehicle of the petitioner, being a truck, was carrying 10 ton of iron ore without any proper documents. Certainly the vehicle was being driven by the driver. The petitioner, the search and the seizure of the goods have been duly considered by the learned courts, and no illegality as such has been pointed out by the counsel for the petitioner so far as the seizure of the goods and the ownership of the truck is concerned. This court finds that the learned court, after considering the materials on record, has ultimately convicted the petitioner for offence under section 4144 of IPC. The learned court has recorded that the petitioner was transporting the seized iron ore for their own profit. And they had the reason to believe that they were stolen articles. It was observed that the learned trial court, after considering the materials on record, has convicted the petitioner by paragraph 22. This court finds that there are concurrent findings recorded by the learned court, and this court is of the considered view that there is no need to have a theft report in order to convict a person for offence under section 414 of IPC. The learned court has referred to the provisions of section 104 within the A of the Evidence Act. The appellate court has also passed a detailed judgment considering the materials on record and has upheld the conviction of the petitioner under section 414 of IPC. ये ओनर कम ड्राइवर क्यों आ रहा है? owner cum driver, no transit challan was produced. Owner cum driver आ रहा है.
ड्राइवर का नाम तो रोशन कुमार झा है. रिपोर्ट दिनेश कुमार मिश्रा एंड ड्राइवर रोशन कुमार झा पार्ट 3.
That is of another truck.
That is of another truck.
2 ट्रक्स हो गए.
आपके ट्रक का कौन था?
मेरा ट्रक
ड्राइवर?
Roshan Kumar Jha.
आपके ट्रक का ड्राइवर रोशन कुमार झा.
रोशन कुमार झा. JH05J50.
After going to the impugned judgments, this court finds no illegality or perversity in the impugned judgments convicting the petitioner so far as it relates to conviction of the petitioner under section 414 of IPC. The fact remains that the petitioner has faced the criminal case since April 2010. And as of now, more than 14 years have elapsed. And considering this aspect of the matter, this court is of the considered view that the sentence of the petitioner be modified for the ends of justice and some fine amount be imposed upon the petitioner. Accordingly, the sentence of the petitioner is reduced to rigorous imprisonment of 1 year with fine of rupees 50,000 to be deposited by the petitioner before the learned court within a period of 6 months from today. In case the fine amount is not deposited, the petitioner will serve the sentence as imposed by the learned courts. This petition is disposed of with the aforesaid modifications.
आइए बुला रहा है.
आपके पास कॉपी है? आइए. Criminal Revision number 1129 of 2013 with IA number, IA का number 112 112 of 2024. इतना 112 ही होगा? 9112 of 2024. The learned counsel for the petitioner submits that as per the order passed by this court on 12/8/2024, today is the last date for filing the surrender certificate. He submits that the petitioner has already surrendered before the court and has been taken into custody, but surrender certificate could not be filed, and therefore he prays for extension of time which has been granted by the order dated 12/8/2024 through this interlocutory application. Considering the urgency of the matter has been mentioned and notified. After hearing the counsel for the petitioner and upon going through the interlocutory application, the time to file the surrender certificate, which is expiring today, is extended till one more week.
And 2nd of September.
Is extended till 2nd of September. That's it. आइए डिस्पोज ऑफ पहले ही फाइल कर दीजिएगा फिर
उससे
लास्ट
पहले फाइल कर रहे हैं, उससे पहले, but still